We've reviewed your complaint, Renee, and we found no evidence of discrimination. No evidence? I have been passed over for promotion 6 times. Every single person promoted above me was less qualified and white. Promotion decisions are based on performance and cultural fit. Say that again on the record, please.
What you just heard was not a confrontation in a back alley. That was a recorded HR meeting inside one of the largest pharmaceutical companies in the southeastern United States. And the woman sitting across that table had spent 11 years building a career that her employer had spent the last 4 years systematically dismantling. Renee Carter was the only Black manager in her entire regional division. She had the degrees, the performance reviews, the tenure, and the results to have been a senior director twice over. Instead, she had watched 6 colleagues, every single one of them white, several of them hired after her, none of them with a record that matched hers, get promoted past her one by one. She had reported it, twice through HR, once to the EOC. She had documented everything, every promotion she was denied, every qualification comparison, every email that revealed what the company's diversity statements carefully concealed. And every time she raised her hand, the company's response was the same 2 words: cultural fit. Those 2 words cost her employer $25 million. And they cost the company something money cannot buy back. The story of what they did to Renee Carter is now told in law schools, HR training programs, and federal courtrooms across this country. This is the full story. Every detail of it is real. Before we go any further, drop a comment right now and tell me where you are watching from. And if you have ever been the most qualified person in the room and still been passed over, if you have ever been told your work wasn't quite right without anyone being able to explain why, if you have ever been the only one who looked like you and felt every decision being made around you instead of with you, this story is for you. Hit subscribe, because we tell the stories that HR departments seal with NDAs and pray disappear. Stay with me. This one is going to hit differently. To understand what Renee Carter built and what was taken from her, you need to understand who she was before she ever walked through the doors of Meridian Pharmaceuticals. Renee grew up in Birmingham, Alabama, the eldest daughter of a schoolteacher and a construction foreman. She had watched her father spend 30 years building things with his hands that other men put their names on. She had watched her mother shape young minds in a classroom that was perpetually underfunded. She had grown up understanding, in her bones, that Black excellence in America required not just talent but endurance. She had taken that understanding to the University of Alabama, where she graduated magna cum laude with a degree in biochemistry. Then to Duke University, where she completed her MBA with a concentration in operations management. She had graduated in the top 10% of her class both times. She had joined Meridian Pharmaceuticals in 2009 as a regional operations analyst. Within 3 years, she had been promoted twice, had overhauled the inventory tracking system for her division, and had been personally commended by the regional vice president in a company-wide memo. She was, by every measurable standard, one of the most valuable employees in her region. In 2013, she was promoted to Regional Operations Manager, the first Black woman to hold that title in her division's history. She believed, at that moment, that she was at the beginning of something, that the trajectory was clear, that the work would speak for itself. She had no idea that 2013 would be the last promotion she ever received at Meridian. The freeze did not happen overnight. That is the insidious nature of what courts call a systemic pattern of discriminatory promotion practices. It happens slowly, quietly, in ways that are designed to be individually explainable and collectively undeniable. In 2015, a senior director position opened in Renee's division. She applied. She had been in her manager role for 2 years. Her performance reviews for both years had been rated exceeds expectations, Meridian's highest performance designation. She had the operational track record. She had the advanced degree. She had the tenure. The position went to a white male colleague who had joined the company 14 months earlier. His 2 performance reviews had both rated meets expectations. Renee requested feedback on why she had not been selected. She was told the successful candidate had demonstrated stronger leadership presence. She asked what that meant specifically. She was told it was difficult to quantify. She made a note of it and went back to work. In 2016, a Director of Strategic Partnerships role was created. Renee had been instrumental in building 3 of the company's most significant distributor relationships. The role was, in many ways, a formal description of work she was already doing informally. She applied. The position went to a white woman who had been at Meridian for 8 months. She had come from a marketing background with no pharmaceutical operations experience. Renee requested feedback. She was told the successful candidate had shown exceptional initiative. She asked for examples. She was told the decision had been made holistically. She made another note and went back to work. This pattern repeated itself 4 more times between 2017 and 2019. 6 promotion decisions in total. 6 white colleagues selected. 6 rounds of feedback that gestured at qualities Renee supposedly lacked without ever producing a single documented example of those qualities being absent from her record. After the 6th denial, Renee did something that Meridian had not anticipated. She stopped making notes for herself and started building a case. Renee Carter spent 8 months compiling what her legal team would later describe in court as one of the most comprehensive discrimination dossiers they had ever seen presented by a plaintiff. She had kept every performance review she had ever received, 11 years of exceeds expectations, ratings, commendations, and company-wide recognition. She had kept every piece of feedback she had received following each promotion denial. She had kept the job postings for every position she had applied for, alongside the publicly available credentials of the people who had been selected instead. She had done the side-by-side comparison that HR had refused to do, and the numbers told a story that 2 words of feedback could not obscure. Of the 6 people promoted above her, none had her academic credentials. None had her tenure. None had her performance rating history. 3 had been at the company for less than 2 years at the time of their promotion. 2 had performance ratings below hers in the year they were promoted. And all 6 were white. Renee also documented something subtler, but equally damning: the pattern of her exclusion from high-visibility projects and leadership opportunities that preceded each promotion cycle. The informal lunches she was never invited to. The cross-departmental task forces where her name never appeared. The company retreats where the relationships that drove promotion decisions were built, and from which she was consistently, quietly absent. It was not just a glass ceiling. It was a glass ceiling with a very specific blueprint. I need to ask you something. Have you ever been the most qualified person for a role and watched it go to someone who looked nothing like your resume? Have you ever been excluded from the informal spaces where careers are actually built, the lunches, the golf days, the after-work drinks where the real decisions get made? Drop a yes or no in the comments, because what Renee experienced has a legal name, and it is about to have a very large dollar figure attached to it. In October 2019, Renee filed her first formal internal discrimination complaint. It was 43 pages long. It included a chronological account of every promotion denial, a credential comparison for each, copies of her performance reviews, and a documented timeline of her exclusion from leadership development opportunities. Meridian's HR department acknowledged receipt. They assigned an internal investigator. The investigation took 11 weeks. The finding: no evidence of racial discrimination. The promotion decisions, HR concluded, had been made on legitimate business grounds. Renee filed her second complaint in March 2020, this time adding documentation of a new development. Following her first complaint, she had been removed from 2 high-visibility projects she had been leading. Her travel budget had been reduced. Her team had been quietly restructured, with 2 of her direct reports reassigned to a white colleague without her input or notification. Meridian investigated again. 11 more weeks. Finding: no evidence of retaliation. The restructuring, they said, had been a routine organizational adjustment. In June 2020, Renee filed a charge with the Equal Employment Opportunity Commission. The EOC reviewed her documentation. They issued a right-to-sue letter within 90 days, a signal that the agency found sufficient grounds to warrant federal litigation. Renee Carter walked that letter directly to the offices of civil rights attorney Dr. Patricia Owens, who had spent 22 years litigating workplace discrimination cases in federal court and had never once described a plaintiff's documentation as superb until she opened Renee's file. "She had done half my job for me before we ever shook hands," Dr. Owens later told the court. That kind of documentation is what happens when someone has been living inside an injustice long enough to understand exactly what it is. The lawsuit was filed in the U.S. District Court for the Northern District of Alabama in September 2020. The complaint named Meridian Pharmaceuticals and 4 individual executives who had participated in the promotion decisions. It alleged race discrimination in promotion practices under Title VII of the Civil Rights Act, retaliation for filing internal complaints, hostile work environment, and discriminatory application of subjective evaluation criteria, specifically the cultural fit and leadership presence, language that appeared in Renee's denial feedback and nowhere in Meridian's official evaluation rubric. That last point was critical, because during discovery, the legal process by which both sides share evidence before trial, Dr. Owens's team found something that Meridian had not anticipated. The terms cultural fit and leadership presence appeared in the feedback given to Renee and to 2 other Black employees who had filed separate complaints. They did not appear in documented feedback given to any white employee in the same division over the same period. Not once. Internal emails obtained during discovery revealed promotion committee discussions that described preferred candidates in terms that employment law scholars testified were coded racial language. References to candidates who fit the culture of our leadership team. Candidates who would be a natural at the table. Candidates who wouldn't require much adjustment. And in one email, sent by a senior vice president to 2 members of the promotion committee 3 days before one of Renee's applications was reviewed, a single line that Dr. Owens read aloud in court to absolute silence in the gallery. "We need someone the team will just connect with. You know what I mean." The case went to trial in the Northern District of Alabama in February 2022. It lasted 9 days. Meridian's defense rested on 3 arguments. First, that promotion decisions had been made on legitimate, non-discriminatory business grounds. Second, that Renee's performance, while strong, had not distinguished her sufficiently from other candidates. Third, that the cultural fit language reflected genuine organizational values, not racial bias. Dr. Owens dismantled each argument methodically. On legitimate business grounds, she presented the credential comparison Renee had built, 11 years of documentation showing that in every single promotion decision, the selected candidate was objectively less qualified by the company's own stated criteria. On Renee's performance, she entered into evidence 11 consecutive years of exceeds expectations, performance reviews signed by the very executives now testifying that her performance had not distinguished her. On cultural fit, she called an expert witness in employment discrimination, a professor of organizational psychology from Vanderbilt University, who had studied subjective promotion criteria for 19 years. The professor testified that cultural fit, when applied consistently to Black candidates and inconsistently to white candidates, is one of the most well-documented mechanisms of structural racial discrimination in corporate America. Renee testified for 4 hours. She was precise, composed, and devastating. She walked the jury through 6 years of her professional life with the same methodical clarity she had brought to overhauling Meridian's inventory system a decade earlier. She did not cry. She did not raise her voice. She presented the evidence the way someone presents evidence when they've been preparing for this moment for 6 years. The jury deliberated for 2 days. The verdict was returned on February 18, 2022. Compensatory damages for $0.2 million. For lost wages, lost promotions, emotional distress, and reputational harm across 6 years of systematic exclusion. Punitive damages, $20.8 million. Because the jury found that Meridian had acted not merely carelessly, but with deliberate indifference to Renee Carter's federally protected rights. That the pattern of subjective, racially coded evaluation criteria applied to her and other Black employees was not an accident. It was a practice. Total verdict, $25 million. Dr. Patricia Owens stood on the courthouse steps in Birmingham and said, "This verdict is for Renee, but it is also for every Black professional who has sat in a feedback meeting and been told their work wasn't quite right, their presence wasn't quite enough, their fit wasn't quite there, and who knew, in their bones, exactly what those words really meant." Meridian Pharmaceuticals issued a statement expressing respect for the legal process and indicating they were reviewing their options. They did not appeal. 14 months after the verdict, they announced a comprehensive overhaul of their promotion evaluation framework, replacing all subjective criteria language with documented, measurable performance standards. They hired an independent diversity auditor to review 5 years of promotion decisions across all divisions. 2 of the 4 individually named executives quietly left the company within 18 months of the verdict. $25 million. And Meridian didn't appeal. Think about what that means. They looked at the evidence. They looked at those emails. They looked at 11 years of performance reviews and 6 promotion denials, and they decided they could not defend it. Does that feel like justice to you? Or does it feel like a company buying its way out of accountability? Drop your answer below. The Renee Carter verdict arrived at a moment when corporate America was still processing the diversity commitments it had made publicly in the summer of 2020. Commitments announced with press releases and infographics and carefully worded statements about belonging and equity. The verdict asked a simple question of every one of those commitments: what happens when a Black employee holds you to them? Employment law firms across the country immediately sent the verdict to corporate clients with a clear message: subjective promotion criteria applied inconsistently across racial lines is not a defensible practice in federal court. The days of cultural fit as a catch-all explanation for promotion decisions that consistently disadvantage Black employees were, judicially speaking, numbered. The case was cited in congressional testimony on workplace discrimination reform within 6 months of the verdict. It was included in the curriculum of 4 law school employment discrimination courses within a year. It became a teaching case at 2 business schools under the title, The Cost of Cultural Fit. Renee Carter did not set out to change corporate America. She set out to be treated fairly in the company she had given 11 years of her professional life to. The fact that fighting for that fairness produced a verdict that is now reshaping how promotion decisions are evaluated in boardrooms across the country is not a coincidence. It is what happens when someone refuses to accept that the most qualified person in the room should have to settle for being the most overlooked person in the room. Before we close, let me give you what Renee's story demands we give every person watching: the knowledge to protect yourself. Title VII of the Civil Rights Act prohibits racial discrimination in every aspect of employment, including promotion decisions. A promotion denial based on race does not need to come with a slur attached. It does not need to be announced. A pattern of decisions that consistently disadvantages employees of one race, combined with subjective justifications that are applied inconsistently, is sufficient to establish a discrimination claim under federal law. Subjective evaluation criteria, cultural fit, leadership presence, team dynamics are not automatically unlawful. But when they are used to justify outcomes that are racially disparate, and when they cannot be defined or measured consistently, courts treat them with deep suspicion. As the Vanderbilt expert testified in Renee's case, the less defined the criteria, the more room there is for bias to operate without accountability. Document your promotions applied for and denied. Document the credentials of those selected. Document every piece of feedback you receive in writing. Document the informal exclusions, the meetings you were not invited to, the projects you were removed from, the opportunities that bypassed you without explanation. Pattern evidence in discrimination cases is built from exactly these details. And file. Do not wait for the company to fix itself. 11 years of waiting taught Renee Carter that the company will fix itself only when fixing itself becomes cheaper than not fixing itself. Let me tell you what Renee Carter's story is really about. It is not about one pharmaceutical company in one southern city. It is not about 6 promotion decisions or 4 executives or a $25 million check. It is about the space between what a company says and what a company does. It is about the gap between the diversity statement on the website and the email that says, "You know what I mean." It is about the distance between the performance review that says exceeds expectations and the promotion committee that still finds a reason to look past the person who earned it. Renee Carter lived inside that gap for 6 years. She documented it with the precision of someone who understood that one day she would need a jury to see what she saw. She waited until the documentation was complete, the legal ground was solid, and the attorney was ready. And then she walked into a federal courtroom in Birmingham, Alabama, the city her father had built things in for 30 years, things other men put their names on. And she put her name on something that will outlast every executive who tried to manage her out of the future she had earned. $25 million was the number. But the real verdict was delivered in those 9 days of trial, in 11 years of performance reviews, in 43 pages of meticulously documented truth. The real verdict was that Renee Carter was always the most qualified person in that room. And now the whole world knows it. If this story lit something up in you, hit that like button. Share this video with every professional you know who has ever been told they weren't quite the right fit, wasn't quite ready, wasn't quite what the team was looking for without anyone ever being able to explain why. Drop a comment. Have you ever experienced what Renee experienced? And do you think $25 million was enough, or should it have been more? I read every single response. Subscribe and turn on notifications. Every week we bring you the stories that institutions spend millions trying to keep quiet. We find them, we tell them fully, and we make sure the people who deserve to be seen are seen. We'll see you in the next one. Stay sharp out there, and remember, document everything, know your worth, and never let anyone redefine your excellence as someone else's convenience.